The following program was produced by the United States Courts.
Supreme Court, the Term in Review, an FJTN program for judges, staff attorneys, and law clerks. Now from the television studios of the Federal Judicial Center in Washington, D.C., your host, John Cooke.
Hello, I'm John Cooke, Deputy Director of the Federal Judicial Center. Welcome to the Center's annual end-of-the-term Supreme Court Review, where we discuss those Supreme Court decisions that we believe are most likely to affect your work as federal judges, law clerks, and court staff. The court issued 74 merit opinions after argument this term and decided 79 cases in all, including 5 per curiam decisions. It reversed or vacated the lower court ruling in over 3/4 of its decisions. The court was unanimous, or all 9 justices agreed on the result in 21 cases, and it split 5-4 in 23 cases. On May 1st, Justice Souter announced his retirement, which became effective when the court recessed for the summer on June 29th. On May 26th, President Obama nominated Judge Sonia Sotomayor of the U.S. Court of Appeals for the Second Circuit to replace Justice Souter. The Senate has not voted on her confirmation as we record this program. Our faculty will analyze about half of the court's decisions from this term and put them in perspective for you. For our discussion, we are again fortunate to have with us Erwin Chemerinsky of the University of California at Irvine Law School, Evan Lee of the University of California Hastings College of Law, Laurie Levenson of Loyola Law School, and Suzanna Sherry of the Vanderbilt University School of Law. The Center's Mark Sherman and Beth Wiggins will moderate our panels. The written materials available online at our website contain summaries of decisions we'll be discussing in the order in which they are discussed, and an appendix with summaries of all the remaining decisions as well. Also in the written materials is an evaluation form that we ask you to print, complete, and fax to us at the number on the form. This is the only way for us to know how helpful this program has been to you and what we can do to make future programs even more useful. Thank you again for joining us. We hope you enjoy the program.
Hello, I'm Mark Sherman. Laurie Levenson and Evan Lee are with me to talk about 4 of this term's Fourth Amendment decisions. The first of these is an important decision in the area of student Fourth Amendment protections. Safford United School District v. Reading involved a 13-year-old girl who school officials reasonably suspected was giving prescription and over-the-counter drugs to other students in school. The female school nurse and assistant principal ordered Savannah Reading to strip down to her underwear and then show them she was not hiding the drugs in her bra or panties. She sued the school district and school officials for violating her Fourth Amendment protections against unreasonable searches and seizures. Evan, what did the court decide?
Well, 8-1, the court decided that the school officials had violated Savannah Reading's Fourth Amendment rights. They found that school officials had sufficient reason to search her bag and sufficient reason to search her outer clothing, but not her underwear. In order for the school officials to have been justified in conducting an underwear search, they needed to show that, number one, the contraband was immediately dangerous, for example, a weapon or drugs that were dangerous even in small quantities. And perhaps also, number two, that they had a specific reason to think that that particular student was secreting contraband in her underwear, for example, a reliable informant, or perhaps a past practice of students at that school in doing that. Here, the contraband was ordinary anti-inflammatories, and there was no suggestion that Savannah in particular had been hiding them in her underwear. Now, school officials are not held to the same probable cause standard as law enforcement officials. But they still do have to have at least a moderate chance of finding wrongdoing before a search is justified.
All right, now Laurie, what about the liability of individual school officials?
The Supreme Court held in this case that the school officials actually had qualified immunity because the lower courts had differed on how New Jersey versus TLO, an earlier decision, would be applied here. Obviously, I don't think we'll have the immunity after that. And even in this case, Justices Ginsburg and Stevens in their concurrence said there should not have been qualified immunity.
And the court cautioned that mere disunity in lower court decisions does not by itself mean that there is no clearly established right. It's not just nose counting. Really, in the end, it's the question of whether the court believes that all things considered, it has laid out a clearly established rule.
All right. Now, our second decision, Arizona v. Gant, is an important change in the court's search and seizure doctrine and the result of an unusual alliance of justices. Laurie, what can you tell us about this case?
Mark, this was a very important search and seizure case. In this case, Rodney Gant is arrested in his car on suspicion of driving with a suspended license. He's handcuffed, put into the back of the patrol car, and then the officers go back to the passenger compartment of the car, search around, find a jacket in the back seat, and in the jacket in the pocket there's some cocaine. They thought that that would be okay because in a prior line of cases going back to Belton in 1981, that type of search would be permissible. But in this decision, the court backs off from that and narrows the police authority.
Okay, now the majority did that by going back to an even earlier decision, right?
That's right, Schimmel versus California, 1969. And in this case, they reaffirmed that under Schimmel, searches incident to arrest are exceptions to the usual rule that warrantless searches are impermissible. The majority held that under Schimmel, these searches are limited to the area within which the arrested person might gain access to a weapon or to destructible evidence. So in other words, a warrantless search is justified only by exigent circumstances of officer safety or by preservation of evidence.
But Justice Stevens, writing for the court, said this is ridiculous. This is not grab area when the suspect's in the back of the car. And he had 3 other votes to go with him on that. On the other hand, he needed 1 more vote. And there was an unusual alliance that he got that vote from. Justice Scalia said you should be able to go back to the car and do the search whenever you have probable cause for an arrest and you're going to find evidence of that crime of arrest, which they didn't have here. So we end up with a mixed opinion. Justice Stevens saying we have to have a real grab area, and Justice Scalia saying it's okay, but only if you're going to have evidence of the arrest, and that doesn't work when you have a suspended license case.
All right, so here the search was no good because the defendant was handcuffed in the back of the patrol car and he was arrested for driving with a suspended license, so no evidence of the offense of arrest could be found in the car.
That's true. Although it is unclear whether this tighter standard for grab area searches is going to be applied outside of the automobile search scenario.
All right, Laurie, what's this mean for the future?
Well, I think what it means is that you're not going to have any more of these automatic searches of the passenger compartments after the car's arrest. On the other hand, the police could take their chance, even under this decision, keep the suspect on the curb near the car, and then do one of these grab area searches. We should also keep in mind that this case doesn't change some other searches. For example, inventory searches or Terry stop frisk. And those Terry stop frisks can quickly develop into automobile searches based upon probable cause.
All right, you mentioned Terry searches, and our next decision involves one of those, and again involved a vehicle being pulled over for a relatively minor offense. This is Arizona v. Johnson. But here, the circumstances and location of the stop played a big part in the court finding the warrantless search permissible. Here, 2 police officers patrolling in a Tucson, Arizona neighborhood known for its gang activity pulled over a car for which the registration had been suspended. Under the court's 2007 decision in Brenlin v. California, everyone in a vehicle is effectively seized by the police for the duration of a traffic stop. While talking to a passenger, one of the officers noticed he was wearing clothing often worn by members of the Crips gang. He also confirmed living in a nearby town where Crips were known to be, and was carrying a police scanner sometimes used by criminals to monitor police activity in the area. Concerned he might be armed, the officer patted him down and found a gun and charged him with possession of the weapon. Did the court find this to be a permissible warrantless search?
Yeah, it did. And this was the latest in a series of decisions in which the court has extended the reach of Terry versus Ohio. With respect to who, in Pennsylvania versus Mims, the court found that once a car had been lawfully stopped for a traffic violation, police may order the driver to exit the vehicle and may pat him down for weapons if there's a reasonable suspicion that he's armed and dangerous. In Maryland versus Wilson, the court extended that rule to passengers. Then with respect to the temporal aspect of it, in Brenlin versus California, the court held that everyone in a car is seized from the moment the car is stopped. And in this case, the court held that the seizure of the drivers and the passengers continues or ordinarily remains reasonable for the duration of the stop.
And certainly the police can talk to the passengers, even about unrelated topics. I think what you're going to see here is fairly standard procedure of police patting down even the passengers, as long as they can articulate some reasonable suspicion and concern for their safety. By the way, it turned out to be a unanimous decision.
Interesting. Finally, we have the court's decision in Herring v. United States. Here, a police officer was incorrectly informed by a clerk from a neighboring county that there was still an outstanding warrant on Benny Dean Herring. A search incident to Herring's arrest turned up drugs and a gun, which Herring tried to have suppressed as the fruits of an illegal arrest. The incorrect information was the result of a mistake in the neighboring county's warrant database. Evan, the court extended its good faith exception here.
Yes, and that rule comes from United States versus Leon in 1984. Basically said that evidence gathered in an unlawful arrest that was made in good faith, where the police believed that they had probable cause to make the arrest, that did not have to be suppressed because there was no deterrence value in suppressing it. Here, the court found that Herring's arrest was the result of negligence, and the search was therefore not an intentional violation of the Fourth Amendment. The court emphasized that the test for negligence is purely objective.
All right, so the issue wasn't whether there was a Fourth Amendment violation, but whether the exclusionary rule would apply.
That's right. The Chief Justice writing for the court said, basically, we don't need the exclusionary rule unless it's a deliberate, reckless, or grossly negligent conduct by the police officer. Here we have an individual officer who made a mistake, not a systemic problem with the police department, and the court said wasn't going to apply the exclusionary rule. This leaves a challenge, of course, for the lower courts to figure out when it is deliberate, reckless, or grossly negligent, but that's the standard the court wants to use.
All right, Evan, what did the dissenters have to say?
Justice Ginsburg wrote that deterrence isn't necessarily the only rationale for the exclusionary rule, that it does prevent a sort of unjust enrichment or prevents the government from taking unfair advantage and restores the status quo ante prior to the unlawful arrest and search.
But I do think you're going to have the prosecutors coming in and asking the lower courts to do this balancing of the deterrent effect versus the cost of keeping out of the evidence. The lower courts trying to figure out, is this one of those egregious situations for the exclusionary rule, or was it like this one where you have the individual officer making a mistake? Overall, I think this is a bit of a chipping away at the exclusionary rule.
Thanks, Laurie. Thank you, Evan. Beth Wiggins will be back in a moment with Laurie and Erwin Chemerinsky to talk about this term's Sixth Amendment decisions.
Hello, I'm Beth Wiggins. The Sixth Amendment to the U.S. Constitution provides a number of rights to defendants in criminal trials. Among these are the right to be informed of the nature and cause of the accusation against them, the right to a speedy and public trial, the right to assistance of counsel, and the right to be confronted with witnesses against them. This term, the Supreme Court decided cases that touch on each of these rights. Laurie Levenson and Erwin Chemerinsky are here with me to discuss these decisions. In Montejo versus Louisiana, the defendant was appointed counsel at his arraignment for murder. Later that day, and before Montejo met his appointed counsel, police secured a Miranda waiver from him, after which he wrote a letter of apology to the victim's widow. All this was done outside the presence of his lawyer. The letter was introduced at trial over his lawyer's objection that it violated the defendant's Sixth Amendment right to counsel. Laurie, did the Supreme Court agree?
No, Beth, the Supreme Court did not agree. In fact, the Supreme Court overturned 23 years of precedent in Jackson versus Michigan and said, as Justice Scalia noted, that there had been a real problem with the states figuring out when the defendant had invoked the right to counsel. So instead, the Supreme Court said it doesn't matter. As long as the defendant is given his Miranda rights and voluntarily waives those rights, there's no separate Sixth Amendment right when it comes to these interrogations.
Yeah. Well, so Erwin, how important a precedent was Jackson versus Michigan?
That's exactly what the majority and the dissent disagreed about. Justice Scalia, writing for the majority, said it's only a 2-decade-old precedent and there hadn't been reliance upon it. Justice Stevens, writing for the dissent, said a 23-year-old precedent should be given great weight, and it is a very important part of the criminal justice system. I think one of the really important things here to emphasize is that Edwards versus Arizona remains the law. If a defendant invokes his or her right to counsel under the Fifth Amendment, then there cannot be police attempts to question or elicit incriminating statements. So this is going to change behavior. Police know that if a defendant waives the Fifth Amendment right to counsel, then they can try to get incriminating statements. Defense counsel want to make sure that their clients invoke the Fifth Amendment right to counsel, and they're going to implore their clients not to speak to the police without counsel being present.
So will defendants, are they basically in the same place now as they were before this decision?
Well, not really, because there's certainly going to be some statements that would not have been admissible under Jackson versus Michigan that now may be. But Erwin's right. It really depends on how many of these and whether Edwards will be invoked and recognized by the court. Basically, Justice Stevens, on the other hand, said that there should be recognized a separate Sixth Amendment interest. Once we have the adversarial process, the defendant needs that lawyer to explain the consequences of waiving the rights.
Well, how about for the courts?
Well, for the courts, we are going to see a bit of a change. Certainly the courts are going to have to figure out when there's been a voluntary waiver. But we know that the federal public defenders are already, in some arraignments, having their clients come, invoke the right to counsel, and putting on the record that they would not be able to make a voluntary waiver at the interrogation without having counsel present.
Oh, that's interesting. Yeah. Well, in our second decision, Ventris versus Kansas, there was no question that police elicited an incriminating statement in violation of the Sixth Amendment right to counsel. The question was whether the prosecutor could use it for impeachment purposes. Erwin?
Ventris was arrested for murder and other crimes. The police put an informant in his jail cell. Both sides agreed here and the court agreed that this violated his Sixth Amendment right to counsel. When he went to testify at trial, he said that his girlfriend was responsible for the crime. The police then wanted, and the prosecutor wanted to use the jailhouse informant to impeach his testimony. And the question was, could they use these statements for impeachment purposes? And the Supreme Court said yes. The Supreme Court said there's a long-standing distinction between using statements for impeachment purposes as opposed to prove the elements of the offense. The court here invoked the distinction of Harris versus New York, which drew exactly this distinction. The court said there's great importance in making sure that testimony at trial is truthful, and allowing the statements in for impeachment purposes achieves that truth-gaining function.
In fact, the court went on to say that preventing the use of it for impeachment would add very little deterrent effect for the police. But of course, the critics are saying, wait a second, this gives an incentive to the police to go ahead and get these statements because at least they'll be able to use them for impeachment. And once the jurors hear these statements, they'll hear that information anyway.
Okay. Our third decision involves the Confrontation Clause of the Sixth Amendment and the court's 2004 decision in Crawford versus Washington. In that decision, the court held that a witness's testimony against a defendant is inadmissible unless the witness appears at trial or if the witness is unavailable, the defendant had a prior opportunity for cross-examination. In this term's decision, Melendez-Diaz versus Massachusetts, the defendant objected to the prosecution offering into evidence what the state called certificates of analysis from the police lab. Here, the certificates show that the substance in plastic bags attributed to the defendant was cocaine. The Massachusetts Supreme Judicial Court held that the authors of the certificates of analysis were not subject to the Confrontation Clause under the Sixth Amendment. Laurie, what did the Supreme Court say?
Well, in this case, Justice Scalia, not surprisingly, wrote the decision. He is the person who authored the Crawford decision in the first place and a real advocate for the Confrontation Clause. And he said that these certificates of analysis are affidavits, and affidavits are the heartline of testimonial evidence, as was said in Crawford. So indeed, there was the right of confrontation.
Justice Scalia, writing for the court, said, "The lab analyst is a witness. Therefore, the statements are testimonial, and they're covered by the Sixth Amendment under Crawford versus Washington." Here, the court emphasized that unless there'd been a prior opportunity for cross-examination, the lab analyst must testify.
But that doesn't mean, as he said, that every witness in the chain of custody has to be called and subject to cross-examination. He also tried to limit the impact on the states by saying that they could have notice provisions that required the defendants to alert the prosecutors as to which one of these witnesses they needed in court.
Well, this was a 5-4 decision, and Justice Kennedy was in the dissent, and we don't see that very often. And also, Justice Kennedy was very vociferous in his view that this was an overly formalistic interpretation of the Confrontation Clause. What did he think the problem was?
I think the problem, he said, was that these affidavits had been admissible for a long time, and that this could have a huge impact and a burden on the states, that these witnesses are categorically different from other kind of witnesses that might be called at trial.
There's tremendous disagreement between the dissent and the majority as to how much a burden this is going to be on prosecutors. Justice Kennedy said this is going to be an enormous burden on state and local governments. He said sometimes guilty people are going to go free because analysts aren't available to testify. Justice Scalia said it's not such a large burden. Many jurisdictions already have analysts testify. He said besides, in most cases, defendants aren't going to insist that the analysts testify. Defendants will be happy to stipulate to the report. And Justice Scalia concluded for the majority by saying even if there's a burden, it's one that's required by the Confrontation Clause of the Sixth Amendment.
Okay, thanks. Our last decision deals with the effect of timing on the rights of the accused. In Corley versus United States, the suspect was arrested for assaulting a federal officer at about 8 a.m. one morning. He was taken to a Philadelphia hospital for treatment of a minor injury a little before noon, and at about 3:30 he was taken to the local FBI office and told he was a suspect in the bank robbery. At about 5:30, 9.5 hours after being arrested, he began confessing to the bank robbery. At 6:30, he was asked for a break and was held overnight. The interrogation began again in the morning, ending with a signed confession. At 1:30 that afternoon, he was taken to a federal magistrate and charged with armed robbery and other crimes. That was 29.5 hours after being arrested. Erwin, why is this all important?
In United States versus McNabb, in United States versus Mallory, the Supreme Court said if there's undue delay before arraigning a suspect, incriminating statements made during the delay are inadmissible. But Congress in 18 United States Code 3501C said that statements should not be excluded because of delay before arraignment, so long as there's arraignment within 6 hours. Ultimately, the question in this case, and it's long been unresolved, is does 3501C overrule the McNabb-Mallory rule?
Does it?
No, it may narrow it, but it does not abrogate it. Basically, what you have here, according to Justice Souter, is that if you have a confession within 6 hours of the arrest, it's not going to be involuntary because of unnecessary delay. But if it's after 6 hours, the court has to make that inquiry whether the delay was unnecessary or unreasonable. And don't forget that this is a rule that's only going to apply in federal cases. So McNabb-Mallory still exists, although we now know how it should be applied.
Thanks, Laurie. Thanks, Erwin. Mark will be back in a moment with Laurie and Evan Lee to talk about some criminal law decisions.
Interesting, all four of the criminal law decisions we're going to discuss in this segment focused on resolving questions of statutory interpretation. The first of these, Boyle v. United States, went to what constitutes a criminal enterprise under the federal RICO statute. That's the Racketeer Influenced and Corrupt Organizations Act. In Boyle, a loosely based group of criminals periodically robbed the night deposit boxes of banks. There was a core group of thieves while others were recruited from time to time. There was no formal hierarchy, leadership, or organization. At their trial, the judge instructed the jury that in order to establish the existence of the criminal enterprise, the government had to prove that there was an ongoing organization with some sort of framework, formal or informal, for carrying out its objectives, and that the various members or associates of the organization functioned as a continuing unit to achieve a common purpose. But over Boyle's objection, The district court also instructed the jurors that they could also find an enterprise where an association of individuals without structural hierarchy formed solely for the carrying out a pattern of racketeering acts, and that common sense suggests that the existence of an association in fact is oftentimes more readily proven by what it does rather than by abstract analysis of its structure. Boyle wanted the court to instruct the jurors that the government had to prove that the enterprise had an ongoing organization, core membership, that functioned as a continuing unit, and an ascertainable structural hierarchy distinct from the charged predicate acts. How did the Supreme Court come down on this question, Evan?
They said that the jury instruction was sufficient. The court said that in a prosecution under Section 1962C of RICO, the government need not prove that an association in fact enterprise had a leadership group or an ascertainable structure, beyond the structure that inheres in the statutorily required pattern of racketeering activity. Court also said that in order to qualify as an enterprise, an association in fact has to have three elements. So first, it has to have a purpose. Second, it has to have a longevity that is sufficient to achieve that purpose. And third, it has to have a relationship among the members.
All right, so Laurie, what's the significance of this decision for the lower federal courts?
Well, the good news is that judges now can use the instructions in these cases as model instructions for their own. And they also have a better sense of what enterprise means. It does mean sort of an ongoing organization. It can be a formal or informal framework. The association, you don't look at it in the abstract. You look at it as it's how it operates as a continuing unit for a continuing purpose. And you certainly don't need a business-like structure as the dissent had suggested.
All right. Now, in Abu el-Hawa of the United States, the petitioner acted alone in committing 2 misdemeanor drug buys, but was convicted and sentenced for 6 felonies because he used a phone to arrange the purchases. Salman Kade Abu el-Hawa took part in 6 calls to Mohammed Saeed, during which he arranged to buy cocaine from Saeed in 2 separate transactions, each time for a single gram of the drug. Abu el-Hawa's purchases were misdemeanors, but Saeed's sales were felonies. However, the government charged Abu el-Hawa with 6 felonies on the theory that each of the phone calls, regardless of who placed them, had been made in causing or facilitating Saeed's felonies in violation of the Federal Controlled Substances Act. Under that act, it is a felony to use any communication facility in committing or in causing or facilitating certain felonies prohibited by the statute. The question the Supreme Court agreed to resolve was whether someone violated the CSA in making a misdemeanor drug purchase because his phone call to the dealer can be said to facilitate the felony of drug distribution. What was the answer, Laurie?
The answer was no. In fact, this was an easy case for the court. It said that facilitating means more than just calling the drug dealer for your personal use drugs. Otherwise, the first-time offender could be charged with a sentence 12 times longer than the recidivist who doesn't use the phone.
Yeah, and the court said that the government's argument would undermine the apparent congressional intent here to treat sellers more harshly than buyers. And the court also pointed out that it would be somewhat odd to speak of the buyer facilitating the conduct of the seller when, after all, it takes 2 to make the sale.
All right. Now, our next decision, Dean v. United States, starts off sounding pretty forgiving. Accidents happen, Chief Justice Roberts begins. But ultimately, that's not the way the court sees it. Christopher Michael Dean entered a bank waving a gun and yelling for everyone to get down. While he was taking money from the teller stations, grabbing bills with his left hand and holding the gun with his right, the gun discharged, leaving a bullet hole in the partition between 2 stations. Dean cursed and ran from the bank. Witnesses testified that he seemed surprised that the gun had gone off. 18 U.S.C. Section 924 criminalizes using or carrying a firearm during and in relation to any violent or drug trafficking crime, or possessing a firearm in furtherance of such a crime. Conviction of that offense carries a mandatory 5-year sentence on top of the sentence for the underlying crime. The mandatory minimum goes up to 7 years if the firearm is brandished and 10 years if the firearm is discharged. Dean got the full 10 years because his firearm discharged. Dean appealed, arguing that the discharge was accidental and that the sentencing enhancement requires proof that the defendant intended to discharge the firearm. But the Court of Appeals didn't see it that way and affirmed Dean's conviction. Evan, accidents happen?
Yeah, but it's a question of what follows from that. The court focused on Congress's use of the passive voice here. Firearm is discharged, which suggests that the government need not prove an intention to fire the weapon. Also, Congress did not include a mens rea element for the discharge of the firearm enhancement, such as knowingly or intentionally.
So I think the court is saying that it wanted to give the most natural reading to the statute. And if you look at it here, the language in relation to in the body of the statute is not really connected to the firearm is discharged in the sentence enhancement. The court basically said that it believed that Congress intended for defendants to be responsible for even unintended consequences, and there wasn't even a reason to apply the rule of lenity because the statute was clear enough.
Okay, now there were two dissents in this case, weren't there?
Well, Justice Stevens, in his dissent, plays off the Chief Justice's opening line, and he says accidents happen, but they seldom give rise to criminal liability. He thought that this would have to be an intentional discharge to get the sentencing enhancement, especially since criminal statutes usually do have a mens rea requirement.
All right, now the court seems to be in a mood to clean up ambiguities in frequently used federal criminal statutes this term. In our fourth decision, Flores-Figueroa v. United States, it resolves a split in the circuits regarding the aggravated identity theft statute. The petitioner here is an undocumented worker from Mexico who originally gave his employer false papers with a Social Security number that was not assigned to anyone. Then, 6 years later, he gave him different papers with a number that belonged to someone else. He claimed that he was unaware it was someone else's Social Security number. The question before the court was, did that matter? Did it, Laurie?
Well, Mark, before I answer that, let's actually look at the language of the statute. 18 U.S.C. 1028 AA1 imposes a mandatory 2-year consecutive prison term on a person convicted of certain other crimes if, during or in relation to the commission of those other crimes, the offender knowingly transfers, possesses, or uses without lawful authority a means of identification of another person. So the question here is whether the government had to prove that the defendant knew that the ID belonged to another person, and the court answered yes.
Well, that's right. And 6 justices seem to say that whenever Congress uses the word knowingly in a criminal statute, that knowingly applies to all the verbs that follow. Justices Scalia and Thomas would not have gone there. They would have rejected that broad rule, and even Justice Alito would not have gone there. He would have recognized a rebuttable presumption that it applies to all the verbs that follow.
And Justice Breyer was not going to hit the immigrants with immigration violations with an extra penalty unless they did know it was someone else's number.
All right, now is there a broader consequence for this decision in the lower courts?
Well, if the court really means to adopt this broader rule, it's going to bring federal criminal law partially into line with the Model Penal Code, which says that whenever a statute specifies a level of requisite mental culpability, that requirement presumptively applies to all of the conduct elements in the offense.
But still, I don't know that there are a lot of rules on interpreting these statutes other than to give them their ordinary meaning.
Well, I am speculating.
Very well. Finally, with Yeager v. United States, we move away from criminal law to a question of criminal procedure. F. Scott Yeager was a senior vice president at Enron until a few months before it filed for bankruptcy in late 2001. For his part in running Enron, and based in part on his sale of several $1 million of his own stock in the company, Yeager was charged with fraud and insider trading counts. The jury acquitted Yeager on the fraud counts but failed to reach a verdict on the insider trading counts. The court entered judgment on the acquittals and declared a mistrial on the hung counts. When the government sought to re-indict Yeager on the insider trading counts, he moved to dismiss, arguing that the acquittal on the fraud counts meant that the jury had necessarily decided that he did not possess material, non-public information that needed to be disclosed, and that the government was precluded from charging him again under the Double Jeopardy Clause of the U.S. Constitution. The district court rejected that argument, and while the appeals court disagreed with the district court, it affirmed the ruling because it could not decide with any certainty why the jury had acquitted. Evan, what was the issue before the Supreme Court here?
The issue was whether acquittals on some counts can have issue preclusive effect when the jury fails to return a verdict on other counts. And the court said yes, following its 1970 decision in Ash versus Swenson. Here, the jury's lack of a verdict on the insider trading counts was a quote-unquote non-event, leaving full issue preclusion effect for the acquittals.
So what the Supreme Court is telling the appellate courts is that they have to look at the record, but that does not include the hung counts, to see if a rational jury could have grounded the verdicts on any issue other than the one the defendant is now claiming is foreclosed.
Okay, Laurie, could you go a little bit more into that point about the appeals court not looking into the hung counts when it examines the trial record?
Well, what Justice Stevens says is that juries speak only through their verdicts, and a failure to reach a verdict doesn't really tell us anything because we don't know why the jury went that way.
Yeah, I mean, he said that there's no way to decipher what a hung count really means. There could be a whole host of reasons, including just sheer exhaustion, that could cause a jury not to come to a verdict. And he said that trying to figure that out, that's not reasoned analysis, that's guesswork, and he said it has no place in issue preclusion analysis.
Although he did say that on remand, the government could ask the circuit to take another look in this case.
All right, and what about the dissents in this case?
Well, Justice Alito wrote separately as well to emphasize that the burden of proof is always on the defendant to show that the issue that he wants accorded preclusive effect was actually decided in the proceeding that resulted in the acquittal.
All right, well, thank you, Evan. Thank you, Laurie. I'll be back in a moment with Suzanna Sherry and Erwin Chemerinsky to look at some of the court's decisions in the area of habeas corpus. One issue the court returned to this term is the application of the one-year statute of limitations for filing habeas petitions under Section 2244D. The general rule is that the one-year statute of limitations begins running on the date on which the judgment became final by the conclusion of direct review or the expiration of the time for seeking such review. But this term, the court considered how this rule applies if the habeas petitioner does not seek direct review. Erwin, what can you tell us about Jimenez versus Quarterman?
Carlos Jimenez was convicted in state court. His conviction became final in 1996. He did not file a timely direct appeal. Apparently, some of the materials for his case were sent to the county jail rather than the state prison where he was located. The state court gave permission for him to file an untimely appeal. The appeal was denied. He filed a state habeas, which was denied. Then he filed his federal habeas corpus petition. The question in this case is, when did the statute of limitations begin to run? Did it run from when his conviction became final in 1996, or did it begin to run after the state habeas proceedings were completed?
Okay, and what did the Supreme Court hold, Susanna?
The court held that when the State Court of Appeals allowed him to file the untimely appeal, that in essence reopened the case. And so at that point, direct review was not concluded yet, and the case was still pending. So the court said you start the statute of limitations from the time of either the conclusion of that direct review, untimely review, or when the time for seeking further review has passed.
I think the larger significance of this case is that once more the Supreme Court looks to the literal language of 2244D, which says the statute of limitations begins to run at the completion of the state direct review. The other more general point of this case is the Supreme Court says it's up to the state court whether to allow an untimely direct appeal.
Which leads to, I think, an important point that we have to be clear about. If he had filed his habeas petition sometime in between, during the 6 years between the time his first appeal became final, or his first conviction became final, and the time he was allowed to reopen the case and file the untimely appeal, if he had filed in between then, he would have been out of luck. It would have started, the statute of limitations would have started running at the conclusion of the first appeal.
All right. In our next case, Cone v. Bell, the underlying issue concerned procedural defaults and, as is so often the case with these questions, centered on whether state law was an independent and adequate state ground barring federal habeas corpus review. Gary Cone's primary defense in his murder trial was that he acted as the result of a psychosis brought on by his drug addiction. The prosecution dismissed that argument and won a conviction and death sentence against Cone. 10 years later, Cone discovered that the government had suppressed evidence of his drug addiction and failed to turn it over to his defense counsel as required under the Supreme Court's 1963 decision in Brady v. Maryland. The state court on collateral review refused to hear the Brady claim, which it ruled had been previously determined in his direct appeal, and ruled that his remaining claims had been waived because he had failed to present them earlier. The federal district court ruled that his Brady claim on habeas was barred by the state court's prior determination. The Sixth Circuit Court of Appeals agreed the Brady claim had been procedurally defaulted by the state court's ruling. What did the Supreme Court say, Suzanna?
The Supreme Court said that the state appellate court's ruling on collateral review didn't add anything at all to its earlier ruling on direct appeal, but was merely a successive rejection of the same Brady claim.
The Supreme Court emphasized here that the state court had decided based on this issue having been previously resolved, not based on procedural default. In fact, the Supreme Court said here there wasn't a procedural default. The Supreme Court emphasized, and I think this is the most important aspect of the case, that whether or not a state ground is adequate is a matter of federal law. It's for the federal court to decide if there's an independent, adequate state ground or decision.
And eventually, at the end, the court decided that there was no reason to conclude that he had waived his Brady claim, and therefore it remanded to the lower courts to determine the merits of the Brady claim, in particular the merits of whether the exculpatory material might have changed his sentence.
All right. Now, we talked earlier about Section 2244D, the statute of limitations on federal habeas claims. Now we're going to talk about Section 2254D, which sets the standard for when a federal court can grant habeas review of a state court conviction. The statute says that a federal court should only grant such review if the state court decision was an unreasonable application of clearly established federal law. In this next case, Waddington v. Sarausad, Cesar Sarausad was convicted of second-degree murder because he served as the driver in a drive-by shooting of 4 students that resulted in the death of one of them and the wounding of another. Sarausad challenged the jury instruction given at his trial as being ambiguous regarding the basis for accomplice liability in this situation. He lost in the Washington state courts but won habeas review in federal district and appellate court. What was the question before the Supreme Court, Erwin?
The question was there an unreasonable application of clearly established federal law? Specifically, the Supreme Court considered this in the context of jury instructions. The Supreme Court said there would be a violation of federal law only if the jury instructions were ambiguous and only if they were likely to the jury to be confused as the requirement for proof beyond a reasonable doubt is to each count. Here the Supreme Court said that the Washington jury instructions were not unconstitutionally ambiguous. The court said that the instructions with regard to accomplice liability met the Constitution's requirements, so relief under 2254D was inappropriate.
All right. And was this decision in any way surprising, Suzanne?
No, I think it would have been much more surprising if it had gone the other way. A few years ago in the Williams v. Taylor case, the court explained that an unreasonable application is not the same as just a merely incorrect application. We're not exactly sure what the unreasonable application standard means, but it seems to be something close to egregiously incorrect.
All right. Now, in our last decision, Hedgepeth v. Polito, it also involved jury instructions. Michael Polito sought to vacate his conviction of felony murder on the ground that the jury instruction was erroneous because it permitted the jury to find him guilty whether he formed the intent to aid and abet the underlying felony either before or after the murder. The California Supreme Court agreed with Polito that the latter theory was invalid, but upheld the conviction on the ground that he was not prejudiced by the error. The Ninth Circuit ruled that it was structural error and that harmless error analysis was not required. Was the Circuit Court's decision upheld by the Supreme Court?
No. The Supreme Court said this is not structural error. The issue in this case is if a jury is given instructions on multiple counts and one of those instructions is incorrect, is that structural error? And the Supreme Court said no. The Supreme Court said harmless error analysis had to be applied.
And under that harmless error analysis, the court has to determine whether the error had a substantial and injurious effect on the verdict. I think this case follows a trend in the Supreme Court that basically denies habeas for most challenges to jury instruction errors unless they had a substantial effect.
I think it also follows the trend that the Supreme Court is very reluctant to find something to be a structural error. The court puts a strong presumption in favor of requiring harmless error analysis.
Thank you, Erwin. Thank you, Suzanna. Beth will be back shortly.